Okay, Kendall's in custody? Yeah. Are we running Kendall? We're running Kendall?
Yes. And that's the matter where we just need Ms. Petrosky to hand you the document of the certified
Oh,
record
we
of
have to
conviction.
continue. Got it.
We've already done all the arguments and everything else.
Gotcha. He's in the breakout. He's in the breakout room. Mr. Etheridge, wait to talk to him. Oh, he hasn't spoken to him. You have to talk to Paige. Are we running Barney?
Your Honor, not had much luck getting Mr. Barney. I don't know what's going on with that.
Okay, he's not here today.
He is not.
You have a number that ends in 6295.
Yes, Your Honor.
Okay.
And I have been trying that number throughout the week.
Okay, what's your big one? Are we running Freeman?
Good morning, Your Honor.
Good
Pardon me.
morning. Freeman, are we running Freeman?
Well, Your Honor, counsel and I were waiting to see whether the people were able to proceed this morning.
Okay, well, are the people able to proceed?
For
I'm sorry.
The minor?
Minor.
Oh, for my, yes. The people will be proceeding victim list with one of our officers. I was speaking with someone. I have to double check that that officer is present. If I can go do that, I can let you know.
Okay, we see Mr. Milks today?
Seeing him, I don't know where he's at currently.
Okay. And then
Ready on Palasio?
is Thibodeau in custody? Yeah, she didn't get right over there. So we have to reset that one. We treat next week as a, or no, they have an exam date? Oh, it's the 18th. When I scheduled it for exam. Wanted to treat that. Correct. Okay. This has been reset, I believe, already. What? This is the 223 file. So did she have a PCC before? No, because she was supposed to be going to like some type of different order. Yeah, she said multiple. Oh. I just wanted to make sure I didn't have to address. Oh, yeah. They didn't read her over again? No, she did just the emails up there. She was trying to break down and barricaded or something. Oh, yeah. The record in the matter of the people of the state of Michigan versus Albert Palasio, file number 23-03335, council appearance.
Prosecutor Paige Petrosky on behalf of the people.
Good morning, Mike Mataloni, on behalf of Mr. Palasio, attorney on behalf of Whitelaw.
How are you, Mr. Palasio?
Good.
Okay, today was the date that was set for sentencing. We reset the sentencing because I did not have this substance abuse assessment. you provide a copy of your assessment to probation?
Yes, I did.
Right, see that it's facts and text.
Yes, you have no the White Office did it for me.
Mr. Mataloni, any additional allocution before sentencing?
Other than the allocution I made last time, Judge, in reviewing the substance abuse, it doesn't appear that Mr. Palasio has a problem at this point in time. I'm asking the court to honor the agreement of no probation.
As indicated by the assessment, did not generate any data suggesting any critical items that needed to be addressed at this time, which of course would be in conflict with the report from probation. Consistent with your Killebrew agreement, the court will sentence you to fines and costs and no upfront jail. The fine is $500, the $75 crime victim rights fee that will be assessed plus a $50 state minimum cost. When will you make your payments?
Tomorrow, Your Honor.
You're gonna pay in full tomorrow?
Yeah.
I'll note that in the file, but you'll make payment in full tomorrow. You can make payment at the criminal traffic window, or you can make payment online using your case number, okay?
Thank you.
Any additional matters for the record?
Nothing from the people.
Nothing further. Thank you, Judge.
You're welcome.
Have a good day.
Thank you.
Yeah. So.
Mr. Mills,
Yes, Your Honor, and good morning.
good morning. Morse, Chad Morse.
Your Honor, I've had the opportunity to speak to Mr. Morris. I've also had the chance to consider Zick. Both of them were leaving on for preliminary examination.
Okay, I'll note that. Thank you. I was just gonna say, I don't see Mr. Gardner. Okay. Mr. Morris?
Yes,
Your attorney has indicated that you're gonna continue to your exam, so we'll see you in person next week.
okay, thank you.
You're welcome.
Thank you, Your Honor.
Thank you. Mr. Samuels?
Good morning, Your Honor.
Good morning. You're here for Mark Gardner.
I am, Your Honor.
On the record in the matter of the people of the state of Michigan versus Mark Stephen Gardner, file number 24-00571, appearance for the record.
Assistant Prosecutor Paige Petrowski on behalf of the people.
And Matthew Samuels on behalf of Mark Gardner, who we are both present via Zoom.
Okay, Mr. Gardner, Today's the date set for a a probable cause conference, that is for arson fourth degree. There is a preliminary examination scheduled April 11th, 9 o'clock in the morning in person at the court. Council, are we continuing to exam?
I believe at this time, I have not had a chance to speak with the people, to see if there is any resolution or what's going on with that. Your Honor, due to scheduling conflicts for next week, I would request an adjournment, on the PE. I do have multiple preliminary exams going next week at this time.
Okay, well, did you advise your client so that he can waive his 21 days?
I did, Your Honor.
Mr. Gardner? You have to unmute.
Hello?
Okay, can you hear me now?
Yes, I can, yes.
Okay, your attorney has indicated that he has a scheduling conflict next week, and you have the right to have a preliminary examination within 21 days of the date that you're arraigned. Due to his conflict, do you want to waive that timeline so we can reset this matter?
Yes, I do.
Okay. Anybody threatening you to get you to waive the timeline?
No, they are not.
Okay. June 20th, work for you?
Yeah,
Yes, Your Honor, I'll
Well,
make
I'm
that work.
asking the attorney.
Yes, Your Honor, I'll make that work.
June 20th at 8:30, at 8:30 in person at the court.
Thank you, Your Honor.
Your Honor.
Mr. Gardner, any questions for the court at this time?
No, I do not.
Okay, you're all set. Thank you.
Thank you.
Okay, good morning, Ms. Wanji.
Good morning, Your Honor.
Is David Bermudez present? No? Too bad. The issue of Bridgeport. Have you been in any contact?
I have not, Your Honor. My messages and phone calls have not been returned.
Okay, I'll issue a Bridgeport. Motion hearing, is someone here for Joan?
Yes, Your Honor, that's good, sorry. That is supposed to be Mr. Scott Nickel. He is caught up in front of Judge JMO at the moment. So if we can pass on that for a bit. Thank you.
Next page. That's Mr. Donnelly's client. Okay, we can bring Kendall up.
Bringing him up. Can I just talk down the hall and just double check which office you're here? Yes, thank you.
I'm confused. It's just in PCC. Where else is mine? After the intersection was getting it. So people think they're dirty on this. Call him for some experiment. So he will be.
Okay.
So, yeah.
Okay.
Maybe. What was it? It was the 21st. On the record, in the matter of the people of the state of Michigan versus Alvin Deshaun Kendall, file number 24-000588 FY, appearance for the record.
Assistant Prosecutor Paige Petrowski on behalf of the people.
And Luke Goodrich from the Public Defender's Office here to represent Mr. Kendall, who's standing to my right today.
How are you, Mr. Kendall?
I'm fine, how are you? No problem.
I'm doing well, thank you. Okay, so today was the date to continue for the preliminary examination bind over. I think I previously, and we checked previously placed my ruling on the record as to bind over. I just lacked one piece of information, which was a certified order of conviction. I believe you have that now.
Yes, I do, Your Honor.
Okay, and Mr. Goodrich, you've seen it?
Yes, I have. We have no objection.
Okay, so with a certified order of conviction from December 14, 2022, let's see. Previously indicated the reasons for the bind over, but bind over will occur for counts 1 and
Right. I believe counts 1 and 6 were going to be dismissed because there was no evidence of felonious assault.
correct. Counts 1 and 6 will be dismissed. For lack of evidence, all remaining counts will be bound over for a bind over date today of April 17th. That's the date the circuit court's going to get the file from the district court, okay? That's not a date that you need to appear in court. Your next court date is going to be a pretrial in circuit court, unless your attorney is going to make a motion for you to be rearranged in the circuit court. You will not need to appear on April 4th, okay? The bond was set at 50,000 cash surety. That will continue. Any additional matters for the record?
Nothing for the people.
Your Honor, I'm just stating the record for Mr. Kendall's knowledge that we do have a final pretrial on a different file with Judge Jamo scheduled for April 18th. So that will be our next hearing with him, and then this other case is just beginning in circuit court.
You have any questions about that, sir? Okay, you're all set for today. Thank you.
Thank you, Your Honor.
I believe we're doing Fonum, is that correct? Who else is downstairs? I haven't seen Mr. Abbott.
Yeah.
I'm gonna be step out.
Oh, you're covering for Mr. Abbott? Have you just spoken to Carter? Are we running Carter? Okay.
Carter is a continuation of an earlier one as well.
Gonna enter the continuation. This is a bit much. You can bring Carter up. On the record in the matter of the people of the state of Michigan versus Divine Fonum, file number 24-000871, FY appearance, please.
Assistant Prosecutor Kendall, people.
Attorney Derek Esterham's Office of the Public Defender on behalf of Mr. Fonum. Your Honor, Mr. Fonum was on video and I was meeting with him in a breakout room, so I don't see him on the screen right now. I don't know if he's still available or not.
He's not, they've switched the person.
All right, Your Honor, I can put down on the record the PCC information if the court would like.
Please do.
Thank you, Your Honor. Your Honor, I met with the prosecutor. She presented a plea offer for Mr. Fonum to plead to malicious use of a telecommunications device. My understanding was that's a 6-month misdemeanor. I presented that Mr. Fonum at this time. He will consider it. We're asking the court to leave the matter on for next week for preliminary examination. Regarding discovery, Your Honor, I did receive the initial filing and some stuff from evidence.com that I'm still reviewing. If there's any discovery issues or investigative issues, I will let the prosecutor and the court know between now and the next court date.
Sounds good. I'll note that in the file. We'll continue to examine next week. It's scheduled for April 11th, 9 o'clock in the morning in person at the court. Fonum's bond, 75,000 cash surety will continue as set. Any additional matters for the record?
Nothing for the people, Your Honor.
No, Your Honor, thank you.
You're all set.
Thank
Who's
you,
in
Your
the jail? Blue on. To the person in the jail with the blue, can you hear me? What's your name?
Jackson.
Can you repeat that again?
Jackson.
Which court are you looking for?
I'm supposed to be helping.
Can you get a deputy, please?
Deputy.
Yes.
Right, please.
Which court is he looking for?
I'm sorry?
Which court are you supposed to be logged into? Because we had Divine Fonum and we don't know who this is.
Oh, for Judge Hellman?
Okay, yep, you're Judge Simmons right now. Yeah, I'm gonna remove the person in it. They're gonna log you into Judge Hillman?
Yes.
Okay, thank you.
Yes.
On the record in the matter of the people of the state of Michigan versus Marquise Carter, on number 24-00162, counter appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good morning, Your Honor. I need to watch from Mr. Gardner.
Okay, how are you, Mr. Carter?
Fine, John.
Today's the date that was set to continue a preliminary examination. And the necessary witness is here.
Yes, Your Honor.
Okay, are we ready to proceed?
Yes.
Okay, you can call your witness.
Thank you. The people will call Mr. John Hayes.
Solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
Thank you. You can have a seat. Please state your first and last name and spell both.
John Hayes, JOHN,
You can proceed. Counsel.
Thank you, Your Honor. Good morning, Mr. Hayes. How are you doing?
Good, how are you?
Doing well. Where do you work?
Judicial Services Group.
And what is that? What is that entity?
One of the functions that we do is provide electronic monitoring to courts and sheriff's offices.
How do you provide that electronic monitoring?
Generally through contract, it's either a GPS tether, an alcohol tether, or a portable breathalyzer.
And what specifically do you do for JSG?
I oversee the entire operation.
Were you working for JSG back in December of 2023?
I was.
And did JSG receive a request for the GPS coordinates for someone named Marquise Carter?
We did.
And do you remember what date you were supposed to check the coordinates for?
I do not. I believe there was numerous dates, but I'm not exactly sure what all the dates of coverage were.
Okay, would December 11th, would that sound about within the time frame when you would assume that you'd be looking through?
Yeah.
And for the December 11th date, when you searched for Marquise Carter, were you able to find GPS coordinates for Marquise Carter?
Yes.
And can you explain, I guess, the process in like, layman's terms of how you determine someone's location when they're on a GPS tether?
Yeah, so the GPS tether is affixed to the client's ankle. It does function similar to what your cell phone does or the GPS in your car. However, both your phone and your car will estimate where it's going to be next. The GPS tether on their ankle does not. We use multiple different forms of technology to identify the actual location, being GPS, cellular triangulation, as well as Wi-Fi.
And how accurate is the GPS tether when it comes to determining someone's location?
It's extremely accurate. Furthermore, when we're looking at a single point, we can tell the accuracy of each individual point to identify a group of or an area of where that point would actually be.
So are you able to, I guess, print off or collect, excuse me, I guess, locations for someone on tether?
Yes.
For a specific date range?
Yes.
And would you be able to, I guess, let me rephrase. When you were able to find those GPS coordinates for Marquise Carter, did you provide anyone with that information after you found those coordinates?
I believe we did. There was I believe it was a detective specifically who had reached out to us to identify the information, and we did send that electronically at the request.
Okay. I'm going to show you, oh, I apologize, I haven't marked this. This is People's Proposed Exhibit number 1. It's a 2 sheets of paper.
Get your sticker.
Thank you. Just the one. Recognize what I just handed you?
I do.
And just briefly, what is STAC?
This is a stops report, which is a report that is ran anytime we're trying to identify a general time frame of where somebody was.
Okay. And to the best of your knowledge, is that an accurate representation of just a printed out version of the stop report
Yes,
done for Marquise Carter?
correct.
Your Honor, at this time, the people have moved to admit exhibit or people's proposed exhibit number 1.
Any objection?
No, Your Honor, just for the purpose of the preliminary exam.
People's exhibit 1 is admitted.
So looking at that report, what is the, I guess, the date range that was searched?
So it begins December 10th, 2023 at 11:10 p.m. and goes until December 12th at 6:39 a.m.
So within that date range, does Mr. Carter's GPS tether place him at the location of 5520 South Pennsylvania Avenue at any time?
Yes,
And when I should also ask, are you able to see how long someone is in a location when you search for their GPS coordinates?
yes,
Okay, and those would also be included in the report.
correct.
So in that report, does it state how long Mr. Carter was at the 5520 South Pennsylvania address?
Yes, approximately 1 hour and 2 minutes.
And does it state the time that he was there?
Yes, 3:26 p.m. to 4:28 p.m.
And you would say that you provided law enforcement with that, this report?
Yes.
No further questions.
Cross-examination.
So how many people do you have on the theater list? Yeah,
Probably 3,500.
and in order, for example, to know where someone is, you cannot control where all the 35 people are at one point, correct?
I cannot control where they are, correct.
Now, so on the way that you control that is if people have exclusions places, correct?
We still can't control where they are. However, some clients do have criteria of where they must be or where they have to stay away from. But again, we can't force them to be anywhere.
Okay, so on those 35,000 people, it's possible that maybe more than 100, more than one person was at that location that day, correct?
It was just to be clear, it was 3,500. And yeah, it's possible somebody else could be there.
Okay, so if someone, the only way you can know or you can reduce the number of people in a place is if there is an exclusion zone. The data will let you know this person was not supposed to be at this place.
There's multiple ways we can identify if all of our clients were at a certain address. We have clients that are on exclusion zones and violate all the time. So even at that case, we can't control where they're at.
Okay, so if for example, if the police did not ask you specifically about Mr. Carter, you would not know anyone else in the group that you are controlling was that place, correct?
We don't actively monitor each point. If that's what you're getting at, that's correct.
Okay, so it's possible that other people from with terror would have been there on that day.
Oftentimes when we get requests from the court or law enforcement, if somebody was at a certain address, we do run a quick report to identify if any of our 3,500 were there. And I believe in this case, Mr. Carter was the only one that was at that address.
You don't know that because you did not have any, you only have the report from him. You did not run those 35,000 that you have under you to see whether or not one was there, correct?
It's a single report that we use to identify all 3,500. We don't have to run 3,500 individual reports.
So you don't know whether or not someone with a terror was at that place also that day.
As of right now, I don't know. I could identify that within 2 minutes.
Okay, so you have to have a request from the police.
Correct.
or for someone.
Correct.
And so it's possible that that day, since you have not run any other check, it's possible that someone else with the data was there.
Possibly.
Okay. And when you did the report, well, I guess I have no more questions, Donna. Thank you.
Redirect.
Thank you. Do you still have exhibit number 1?
I do.
Could you look, I know there's the 2 pages that are all part of the report, but if you look, I believe it would, the top of the page is titled the company proximity report.
I believe, yes, I do have that.
Okay. And do you recognize or what a company proximity report is?
Yes, the company proximity report is the report that I had referenced just a minute ago, where we run a report to identify all of the clients that were at a certain address during a certain time.
Okay, and so that was included in the information you gave to Lansing Police?
Correct, I actually missed that earlier.
Not a problem. On that report page, are there multiple people who were within the, I believe, the 500 feet of the 5520 South Pennsylvania address?
Yes, there were 3.
And when you are running a report with multiple, or to see where multiple people are in reference to an address, can you see how close or how far they are from that address?
Yes.
Okay. And that would be included in that report?
Correct.
On that report, how close or what was the proximity between Mr. Carter and the 5520 address?
13 feet.
And in your experience, what does that indicate?
He's at that address.
Okay. For the person on tether listed below him, does it state his proximity to that address?
It does.
And what is that proximity?
239 feet, and to clarify, that was for one single point, which often means travel.
Okay, so in your experience, is it there? What would that indicate to you?
Either 1, they're traveling, or 2, they're at a nearby address.
Okay, but not necessarily at that location.
Correct.
And then for the person with the GPS tether listed below that individual, what was his proximity to the 5520 address?
471 feet.
And what does that distance indicate to you?
Same thing, either at a different address, but again, that was 1 point, so oftentimes that'll be travel, someone driving down a nearby road.
Okay, so taken all together with those 3 individuals listed on the report, of those 3 individuals, who, if any, based on your experience, would you place at the 5520 address?
1 only, and that being Marquise Carter.
Okay, thank you. No further questions.
Follow up, Donna.
Well, I don't know, well, there's a follow-up, because she only asked those questions based on your questions. She didn't go outside the scope.
I'm not going to go outside.
Well, then if I let you read it, this is her witness. So if you recross, I have to let her redirect again. The objection to her follow-up.
No objection, Your Honor.
Proceed.
Have you been at that place? Do you know how big the address area is?
I have not been at that address itself, but I've been in the area many times.
Okay, so when the GPS cannot pinpoint where which place my client was, he said that it was at the address, but he cannot say it was at the office, it was in the lot looking at the car and those kind of stuff, correct?
We can, with a 13-foot accuracy, I can tell you with 99.9% surety of exactly where he was.
Okay, from the report that you have, or if you go and make some more report, a check.
Either. Anytime we send a proximity report or a report at all for locations, we personally verify those points. If there's anything that we don't agree with, we will point that out and modify the report prior to sending it.
Okay, my question is, from what you testifying, were you able to pinpoint at where my client was, whether he was at the office or he was in the lodge?
I can't recall being December, but I'm telling you, if we're putting him 13 feet at that address, he's at that address.
To the best of your knowledge, do you know what business it is?
I do not.
Okay, so if I tell you that it's a car business, you won't doubt what I'm saying.
Correct.
And if it's a business selling cars, it's possible that there are many cars in the lot, correct?
Correct.
And when people come to look at cars, they walk around the lot to look at something that would be interesting for them.
Possibly.
Okay, and so you cannot say with precision where in the lot Mr. Carter was. Is that correct?
I could say with accuracy where he was in the lot.
He was in the office,
If I was looking at the points on a map, I could tell you with accuracy where.
but
he
you
was.
cannot, you not look at it. Did you look at that, or can you testify now that you know where he was?
I looked at it prior to sending the report. I did not look at it this morning.
So you don't know.
Sure.
Thank you.
Redirect.
No redirect, Your Honor.
Thank you. May this witness be excused from the stand?
Yes, you.
And you can publish your exhibit.
Oh, thank you.
Mr. Hayes,
Thank you, Judge.
any additional witnesses?
Yes, Your Honor. The people will call Detective Garrett Hamilton. And we'll go get him.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
Thank you. You can be seated. You can proceed, counsel.
Thank you. Excuse me. Good morning, Detective.
Morning.
Could you state your first and last name and spell them?
Detective Dale Garrett Hamilton, DALEGARRETT HAMILTON.
Thank you. And where do you work, Detective Hamilton?
Lansing Police Department.
What are your duties?
I'm a police detective. I work auto theft currently.
And were you working as a detective on December, in December?
Yes.
And when you were working in December, did you have reason to be investigating a car theft at Paradise Motors?
Yes.
And if you could just briefly, what was your role in that investigation?
The initial report was taken and then the case was assigned to me for follow-up.
And what did follow-up entail?
At that point, a suspect had been identified already. I was able to contact GPS services. Suspect was on tether and located tether information for his whereabouts at that time. And I also contacted the individual whose information was used to obtain the vehicle.
Okay, so I want to talk a little bit about the contact that you had with that person.
Okay.
So Did they provide their name?
They did.
Okay, and what was that?
I'd have to
Okay,
refresh my memory with the report.
yes, I have their report.
Apologize, I get a lot of.
Understandable. I believe the contents of your report are on this page here, but the entire report is here. Maybe you can just look up when you're done.
I made contact with Nichelius Campbell, date of birth 3/14/98.
And all set. So, the contact that you made with Nichelius Campbell, did you ask him, about test driving a vehicle at Paradise Motors?
Yes.
And did he,
Hearsay on it.
Excuse me?
Hearsay. I'm
um,
just anticipating.
There was an objection.
thank you, Your Honor. If I were to finish the rest of my question, anticipated testimony would fall under the hearsay exception for preliminary exams, related to possession, use, ownership, or, authority to use. As I was going to be asking about, Mr. Campbell's, use or non-use of vehicles at Paradise Motors.
Objections overruled.
So, did, Mr. Campbell, did he, indicate whether he had, used a vehicle at Paradise Motors?
He denied ever having test driven or been to Paradise Motors.
At any point in time? And then. I just want to make sure that I'm not missing anything. Oh, and do you remember what the make and model of the stolen vehicle was?
I don't, I'd have to refresh my memory again, I'm sorry.
That's all right.
The vehicle was a black and color 2013 Dodge Ram pickup 1500.
So you said that the scope of your investigation, you investigated the JSG results, and then you also made contact with Mr. Campbell. Did you take any other actions in the course of your investigation?
I had spoken with parole agent Nancy Hamilton, who's familiar with Mr. Carter. And she reviewed video, said that was Sam, had identified him, provided
That
Facebook
objection,
information.
you're on the hearsay.
Do you want to respond to the objection?
I would just say that it's not being offered for the truth of the matter, sir. It's just is being.
What is it being offered for?
It was just being offered to, I guess, speak to what other actions he may or may not have taken in the course of his investigation.
Have further argument as you just sat up and sat back down, so I wasn't sure.
You know, it's hearsay.
She states it's not being offered for the truth of the matter asserted, which I struggle with that because we're talking about identity theft.
Identification.
And we've already had testimony directly from Nancy Hamilton, so you don't even need it. The objection sustained.
Understood. Thank you, Your Honor. No further questions.
Thank you.
Cross-exam.
Thank you, Anna. Detective Anderson, when you talk to the person whose identification was stolen or allegedly stolen, the person did not identify my client, correct?
Correct.
He did not know of my client.
Correct.
I have no further questions.
Let me redirect.
No, Your Honor.
Thank you, Detective Hamilton. You've been excused.
Thank you, ma'am.
Any further witnesses?
No, Your Honor.
She's all set.
Is the defense calling witnesses today?
No, Your Honor, thank
you. You can proceed to argument.
Thank you, Your Honor. Mr. Marquis Carter, in this case, is charged with one count of identity theft, one count of false pretenses, and one count of unlawful driving away. of an automobile. Previously, we heard testimony from Mr. Cogswell, who was working at the 5520 South Pennsylvania Avenue address, which is the location of Paradise Motors, a car sales business. His testimony stated that on December 11th, 2023, that an individual came into his store, or into the store where he was working. He provided a name of, I believe, Nicholas, or excuse me, Nichelius Campbell, and that they did a routine, basically background check or credit score check before permitting that individual to then take a test ride of one of the vehicles. He was not 100% positive about the identification of the individual who came in. He said that he sees lots of people throughout while he's working, so he didn't have a lot of specifics. But he was able to establish that the person who came in did use the identifying information of Nichelius Campbell, and that and that the vehicle belonged to Paradise Motors when that individual took possession of the vehicle and drove it away, and did not return the vehicle. So we then also heard testimony from Ms. Nancy Hamilton, who is a parole officer with the circuit court. And she was contacted because Mr. Cogswell believed that he had witnessed a GPS tether on the individual who had come in to test drive the vehicle. So at that point, she was able to contact JSG, do some further investigation, and was able to identify Marquise Carter via his Facebook account at that time, and was able to identify him in court today, or excuse me, on court on that date. Then today, we later heard testimony from Mr. John Hayes, who the representative from JSG, and he was able to state that he provided law enforcement with a JSG report of the GPS locations of Mr. Carter, and was able to state that Mr. Carter was the only individual who he could state with 99% accuracy was present at Paradise Motors on that date and time, and that Mr. Marquise Carter's was there for approximately an hour and a half. We then also heard testimony from Detective Hamilton, who spoke to his role in the investigation and also confirmed with the victim whose identity was used that the victim had never been present at Paradise Motors, had not test driven a vehicle, and had not provided their information to be used for a test drive. So from the testimony provided today, I believe that the elements of these three charges have been met to a probable cause standard, and ask that the court find over this case is charged.
Ms. Wangji.
Thank you. As for the identity theft, Your Honor, I would say that there was no identification of my client. There was a testimony from the detective that he talked to the person whose ID was allegedly stolen, but there is no testimony regarding, and that the person said that he did not he did not go to that business place on that day. But no picture of the person was presented to the cell person to see if that person was telling the truth. Because if we have the cell person who was not, is my understanding from the note of Mr. Abbott, was not able to identify my client when the person was here in court.
You're talking about the Mr. Cogswell?
Yes.
He said he wasn't sure. He said, and I quote, I have a lot of customers that look like him. I think I questioned him, what do you mean look like him? And he wasn't able to identify, but Ms. Hamilton identified.
Well, Ms. Hamilton identified my client from someone in the Facebook. And what the person here in court, it's my understanding that she was not able to say that my client looked. She said she looked like the guy on Facebook. The guy on Facebook looked like the guy on Facebook, but the picture on Otis did not look like the guy sitting next to me.
I recognize he doesn't like the guy sitting next to you now, but he had different hair than So I talked about it in court myself.
So, my client had, the only thing that is able to put my client there is a GPS, but there were three other people there who had GPS. And there could be 200 people going at that business. It's a business place, it's a place where cars are being sold. So there can be 200 people in there who went there.
On GPS tether. But the witness who, I mean, this is some sophisticated equipment we're using here.
Yes.
Otherwise, courts across the country, state, local, federal, wouldn't be using GPS tethers if it didn't have some level of sophistication and accuracy, don't you think? No?
Well, again, for the accuracy, we would want to know when was this is a machine. We want to know when the machine was accurate at that time.
When was it what?
If the machine was accurate.
Okay, no one questioned that, whether or not there was a glitch in the system. Has it been tested recently? No one asked any of those questions when he was here. He testified that he's 99.9% sure with accuracy that this GPS tether, which was attached to the ankle of your client, was within 13 feet of this address. And of all the other 3,500, I think you said, people in the city of Lansing, Ingham County, that are on this tether system, there was no one within 100 feet of there. And not only was he indicated or located by tether in that area, within 13 feet of that area, but we're talking about 7 minutes at 3:25 p.m. and then 1 hour and 2 minutes at 4:28 p.m. That his tether was pinged in that location. And so you don't believe that there's sufficient probable cause? Is that your argument?
Yes, Your Honor.
Okay, thank you. Any further argument?
No, Your Honor.
Okay. Re-argument.
No, Your Honor, thank you.
Today's the date to conclude the preliminary examination. Mr. Carter, this information is for you. The attorney already knows this information, okay? The preliminary examination is a hearing that is to measure probable cause. This is not a trial. Probable cause is more than mere suspicion that the crime alleged occurred, and more than mere suspicion that you're the individual that committed the alleged crime. So this is not a situation where they need to prove elements beyond a reasonable doubt. Burden is extremely low. It's based on the testimony and the evidence presented during this hearing, and it's also the court's responsibility to assess the credibility of the witnesses and to make a determination as to whether or not the people would have a likelihood of success at trial on these charges. You're charged in count 1 with identity theft, count 2 false pretenses, 1,000 or more but less than 20,000, and count 3 motor vehicle unlawful driving away. If this were to be presented to a jury at a trial, the prosecution would have to prove each element of identity theft beyond a reasonable doubt. That being that you did in fact, beyond a reasonable doubt, defraud or intend to defraud or violate the law, where you use or attempt to use personal identifying information of an Achilles Campbell to commit the unlawful driving away of a motor vehicle. We had testimony back on February 15th from a Harvey Croswell. He indicated that he was employed at Paradise Motors, that on the date of December 11, 2023, he would have been working at that time. The location of Paradise Motors of 5520 South Pennsylvania Avenue, City of Lansing, Ingham County, State of Michigan. He says he does auto sales and repair. He indicated that a vehicle was stolen that day and put out for a test drive, but was not returned. When questioned to whether or not he could identify the person sitting next to at the time, Mr. Abbott, as the individual that test drove the vehicle, he struggled. He stated again, and I quote, that he believed that that was the individual, but he was not sure. He said that he has a lot of customers that look like the person in court. I wanted to know exactly what does that mean? Do you have a lot of customers that are black? Do you have a lot of customers that have braids and or dreads at the time? He indicated that he had a lot of customers that wear their hair in that form and fashion, and so he wasn't able to, with accuracy, identify this individual as the person who came in to test drive the vehicle. He indicated that the suspect did give the name of an Achilles Campbell, and that he ran that credit for an Achilles Campbell, and that the suspect took the vehicle out for a test drove. It was a Dodge pickup, he believed, 2011 black Dodge pickup. That vehicle was not returned. We then had testimony from Nancy Hamilton from the Michigan Department of Corrections. She's a parole agent. She indicated that on December 12th, the following day, 2023, she was contacted by a Matt Finley over the radio about a vehicle taken off the lot and not returned, and that person had been on a tether. The witness, Ms. Hamilton, indicated that the individual, Marquise Carter, had previously been on parole probation out of her office. And so for those reasons, she was at least marginally familiar with him, that she based her information provided to her through JSG. She was able to identify a picture of Mr. Carter through Facebook. We had testimony today from John Hayes from JSG. He testified that on or about December 11th, that there was a request for coordinates to be provided from the tether of Marquise Carter. He testified that these GPS tether coordinates are extremely accurate, and that they are accurate as they identify the location points of the individuals wearing the tether. He provided what has been marked as People's Exhibit 1, which is a stops report, and he indicated that this report was ran when trying to, or is run, I should say, when they're trying to identify the location of someone. I am going to also put on the record that the whole purpose of the GPS tether is so that we can track people when they're not in the custody of the jail. That's why when we have bond motions from defense counsels, they say, well, Your Honor, we don't need to hold them in jail because this could be sufficient through GPS tether, so that the court can track where they're going. So if there was no level of accuracy, why would the court be relying on them? I have a stops report that indicates Mr. Carter, the individual sitting before the court, was at the location of 5520 South Pennsylvania Avenue, City of Lansing, Ingham County, State of Michigan, on the date and time in question, that being December 11, 2023, from 3:26 and 5 seconds to 4:28 and 5 seconds. From there, he went to 6031 South Pennsylvania. He was there for about four minutes before he went to 38 North Aurelius, back to 6200 South Pennsylvania, which we know from our experience to be the South Side Myers, and then to 300 Curry Lane, and then to 5723 Richwood Street, and then to 816 Louisa Street. As to count one of identity theft, I think there is more than sufficient probable cause as to bind over to count one identity theft to the circuit court. Count 2 is false pretenses, alleging that there was an intent to defraud, cheat, or make the false pretense to obtain from a person money, personal property, or use of an instrument, facility, article, or other valuable thing of service, and that the value needed to be within the amount range of $1,000 or more, but less than $20,000. The people would need to prove at trial each element beyond a reasonable doubt. First, that the defendant used a pretense. Second, that the defendant knew that the pretense was false at the time that he used it. Third, that he used a pretense and intended to defraud or cheat someone. Fourth, that another person relied on the false pretense. Sixth, that by relying on this pretense, this person suffered the loss of something valuable. Sixth, that the amount of loss has a fair market value at the time. In this case would be section B, $1,000 or more, or less than $20,000. The definition of a pretense is the use of a statement, writing, or any other device that is false or that could mislead the person it is presented to. A pretense is to knowingly make someone else believe something that is false, or keep someone else from finding out information important about property involved, or to sell, transfer, mortgage property while hiding a claim or other legal obstacle, or to promise to do something or have something done knowing that it's really not going to be done. In this case, we're looking at section A, to make someone believe something that is false. The court is satisfied that there is probable cause that this defendant made a statement to a representative by the name of Harvey Coswell at Paradise Motor that he was an Achilles Campbell in an effort to have Achilles Campbell's credit ran and be able to leave the lot with a pickup truck, 2011 Dodge pickup truck, which was valued in between the ranges of $1,000 or more, but less than $20,000. Count 2 will be bound over to the circuit court. Count 3, motor vehicle unlawful driving away. Based on the same testimony, the court is satisfied that there's sufficient probable cause to bind over as charged. Count 3, motor vehicle unlawful driving away. Bind over date for all 3 counts is going to be April 17th. That's the date the circuit court's going to get the file from the district court. Mr. Carter, you're not appearing in the circuit court on that date unless your attorney is making a motion for you to be rearranged at the circuit court, okay? Your next court date will be a pretrial in the circuit court. Your attorney will be made aware of that. Do you have any questions at this time? Bond is set at $7,510. That will continue the additional matters for the record.
Nothing from the people.
Nothing yet. Thank you. You're all set.
Okay, for a second.
Yes. I don't know if we've seen Mr. Nichols.
Your Honor, my man.
Yes.
Last I have heard from him, he thought he would be here by 10 o'clock. I will ask him for an update. Thank you.
Oh, hey. Oh, there, you must have known. Yeah.
They didn't even notice the probation.
He was just asking for an update.
On the record in the matter of the people of the state of Michigan versus Marvis Jones, file number 24-00473FY, counsel appearance.
Assistant Prosecutor Peter Petrosky on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Mr. Jones, who is present by apology.
Okay, today was the date and time. It says set for motion, but I don't have any indication as to what the motion is for, and I don't have a motion in my court file.
It was for a redetermination of bond, Your Honor.
Okay, I requested that there be a bond report. I don't think I received one.
I have not received an updated bond report and haven't heard anything from pretrial services.
And neither have I.
And at this time, he's currently housed. I think in county jail, is that correct?
Correct.
Bond was set at 5,000 cash surety, and your bond motion was
500,000.
500,000 cash surety. Correct.
I'm requesting either a reduction bond or a consideration of PR with tether and house arrest. He does have his grandmother in the courtroom who he could reside with. He's got a case pending before the juvenile court, which also yesterday now has a $500,000 cash surety bond. He is very young. The complaining witness and the other two lay witnesses did not appear at the last time that was set for a preliminary exam. I don't know whether they will intend to appear at the next hearing. So I'm just looking for an opportunity for Mr. Jones' bond to be lowered so that he can be potentially released to his grandmother. He is 17, will turn 18 this month. He's a very young man. These are serious charges, but he does have a place to reside and is willing to be on house arrest with GPS tether, who ensures attendance at court and the safety of the community while he's out.
Yes, two separate bonds amounting to a total of $1 million right now.
Correct.
So I would imagine that these are serious charges over at the juvenile court.
The juvenile court is a breaking and entering of a brick building. Allegations are that Mr. Jones and two other individuals went into a garage.
Oh, okay.
The
Well,
judge,
these are assault with intent to murder
correct,
and carrying a concealed weapon and felony firearm. So breaking and entering, that's a crime against the property. These are allegations of assault of and a violent nature. And my understanding is that the address that you're saying he can live with was the address he was living at before this alleged incident.
that is where he had been residing prior to this incident.
So those aren't circumstances that's going to present the court with any comfort that there would be any more oversight than at the time of this alleged incident. I need a bond report. I don't have a prior criminal history. I literally have the same things that I had last time, and I said I needed these things. I don't have anything. The other question that I have, the March 14th date, witnesses didn't appear?
No, the lay witnesses were not present on that date.
Was that due to a subpoena issue?
Let me check my notes. I believe that's the case though.
My understanding that I believe that people cannot locate any of those witnesses at this time. They may not have been able to subpoena them. There were several officers here.
So essentially, he can't get out until he posts another bond anyways.
Correct, and when the bond was set yesterday in front of Judge Garcia, Tuesday, So this week, Judge Garcia did say if the court made any modifications to this bond, he would consider doing something similar. He set the,
Judge Garcia might have had more information than I did when he set that bond. That I don't have his prior criminal history. So this was my first knowledge that he had another case. Ms. Petrossi, can you follow up with pretrial services and get me a bond report?
Yes, Your Honor.
I can do that as well.
And I can have this reset for next week. You can do April 11th at 9. No problem. Do you have any questions today, Mr. Jones? Okay, any additional matters for today's record?
Nothing from the people.
Nothing for the defense. Thank you.
Okay, you're all set for now. This is Mr. Brown. That's another continuation. Is that correct?
That's correct, Your Honor. Can I check for witnesses briefly?
Sure.
Thank you. So the necessary witness isn't here to continue the Brown prelim, so people are unable to proceed today.
On the record in the matter of the people of the state of Michigan versus Damari Brown, file number 24-00245, counsel appearance.
Assistant Prosecutor Keith Petrosky on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, Damari Brown, who is present in the courtroom.
Okay, Mr. Brown, we're continuing your examination on this matter because we needed the testimony of Victoria Johnson. Let's see. Or have subpoenaed her and she did not appear today. Is that correct?
That's correct, Your Honor.
My understanding, she did appear before, but then left before a case was called. My understanding is you did speak with her the last time.
Yes, when she was present, we both, yes. Both times.
She had a dentist appointment or something, was it?
She didn't say what.
Oh,
She
okay.
didn't tell me why she.
Okay. And have you had any communication with her since the last court date?
I have not been able to get in touch.
Oh, okay, sounds good. How do you want to proceed?
Your Honor, at this time, they are unable to proceed, would be asking for this to be dismissed without prejudice.
Motion to dismiss without prejudice is granted. Did you have the right to reissue the charge against you within the statutory timeframe if they re-engage with the witness and she's ready to proceed? Do you understand that?
Yes, ma'am.
Do you have any questions at this time?
No, ma'am.
Any additional matters for the record?
Nothing from the people.
We'll get you a copy of his knowledge.
Yes.
We're all set. Thank you.
The Egg River Section Center.
We just need. You need a highlighter, you said?
Yeah.
Find one.
No, I'm not.
Oh. Oh, wait a minute.
No, no, no.
Now I'm
Oh,
putting away my.
I know, that sounded bad. I should have said I can't use anything but yellow, because when I scan it, it blacks it out.
Okay. I was gonna say, what's the matter with pink?
That came across.
Yeah.
Okay, on the record in the matter of the people of the state of Michigan versus James Minor. I'm sorry, wrong case. This is Hodge. People of the state of Michigan versus Thomas Hodge, file number 24-00293. Council appearance.
This is Prosecutor Paige McCroskey on behalf of the people.
May I please support David B. Carter Jr. on behalf of Mr. Hodge, who is present sitting at council table.
How are you, Mr. Hodge?
Good, man. You?
I'm well, thank you. Okay, today's the date that was set for preliminary examination. And are we ready to proceed?
Yes, we are, Your Honor.
Yes, sir.
Any preliminary matters before we call witnesses?
Just briefly, I've spoken with Mr. Carter and he's agreed to stipulate to Mr. Hodge's prior criminal record, specifically his conviction for home invasion first degree in September 7th of 2011.
That's correct, counsel.
For preliminary exam purposes only,
Any additional preliminary issues?
No.
I would ask that all witnesses be sequestered.
Sequestration is granted. How many witnesses do you have?
Two.
Your officers?
Yes.
Okay, you can call your first witness.
Thank you, Your Honor. People would first call Officer Nicholas Rincon. Okay. That's
Solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
You have a seat. You state your first and last name and spell both.
Nicholas Rincon, NIKOLAS,
Thank you, counsel. You can proceed.
Thank you, Your Honor. Good morning, officer. How are you doing today?
Good.
Where do you currently live?
Lansing Police Park.
And what are your duties there?
I am a patrol officer.
And what does that entail?
I take calls that I'm dispatched to, and I do proactive police work such as traffic stops, things as such.
Were you working as a patrol officer on February 1st, 2024?
I was.
And on that date, were you dispatched to 1121 Keystone Avenue?
Yes.
And is that the LAFCU bank?
Yep, the last year.
And why were you dispatched on that day?
I was dispatched there for a suspicious person possibly involved in a fraud. The dispatch gave me a description of the vehicle and I talked to that.
Okay. So did you go to that location?
I did.
I should ask. Is the 1121 Keystone Avenue, is that in the city of Lansing?
It is.
In Ingham County?
Yes, sir.
State of Michigan?
Yep.
So when you got to LAFCU, what did you do first?
As soon as I pulled into the parking lot, I saw the vehicle that was matching the description that was dispatched. And I also noticed that it was parked over a handicap line. So I went and made contact with that vehicle.
Okay, was anyone present in the vehicle?
Yes,
And did you speak with that person?
I did.
Did they provide their name?
Yes,
What was it?
Mr. Hodge.
And were you able to see his face?
I was.
Would you recognize him if you saw him again?
Yes,
Is he present in the courtroom?
he is.
And can you describe what he's wearing and where he's located?
Right now?
Yes, right now.
Blue shirt and glasses. Dress.
Let the record reflect that the witness has identified the defendant.
Any objections, ID?
No objection.
ID is noted.
So when you spoke to, or I guess I knew your phrase, what did you speak to Mr. Hodge about?
So I went and spoke to him immediately due to that parking violation being on a handicap. And as soon as I made contact with him, I noticed an open container of alcohol in the center console.
You noticed what?
Open container of alcohol.
Oh,
And what did you do after you observed that alcohol?
I asked him to step out of the vehicle.
And why did you do that?
Typically because I'm going to search the vehicle when I find an open container almost anytime. It gives me a probable cause. So I had him step out, walk to the back of the vehicle, and then we continued our conversation from there.
Okay. And did you ask him anything about the open containers?
Yes, he advised that they were old.
And then were other officers present with you?
Yes, my partner, Officer Meekoff, was with me. He went inside of Blackview at the time to make contact with the other subject that was described to be inside.
Okay. And so after you have Mr. Hodge out of the vehicle and we're speaking with him, what did you do after that?
So I was speaking with Mr. Hodge, talking about the open container. I noticed that he was getting extremely nervous about it because I told him I was going to search the vehicle, and it eventually led to me detaining him in handcuffs.
And when you say he was getting really nervous, why did you think that?
Pacing back and forth, body language. He was visibly upset when I informed him that I would be searching the vehicle.
And so you stated that you placed him under arrest?
I detained him at that time. I didn't know if I was going to be taking him to jail for the open container, but I did place handcuffs and I informed him that he was detained at the moment.
Okay. And what did you do after that?
I searched the vehicle.
And what did you find in the search?
I located under the driver's seat a firearm inside of a fanny pack or a small black bag. I loaded.
Sorry, I'm gonna stop you there. We're just gonna go step by step. So
okay.
With the firearms, you said that was under the driver's side seat?
Yes, ma'am.
And that was the seat that Mr. Hodge was sitting in prior to you having him exit the vehicle?
Correct.
And what kind of firearm was it?
It was a pistol. I can't remember the brand. If I referred to my report, I would be able to do that.
That's okay. I just wanted to know if it was a long rifle, a handgun.
Pistol.
Pistol. Okay. And so then, did you find anything else under the front driver's seat?
I did. I believe it was around 30 grams of meth, give or take, somewhere in that ballpark. I can refer to my report to give you the exact weight. And then I also found in the driver's side door storage area, I believe 5 grams of crack cocaine.
So when discussing the methamphetamine, first of all, what did it look like when you observed it?
It's a white crystal rock-like substance. I deal with it a lot, so typically looking at it, I can usually guess what it is, but I true narc everything. So.
And did you true narc it in this case?
I did.
Okay, and what was the result of the true narc test?
Methamphetamine.
Okay, so it was positive.
Yeah, came back positive for methamphetamine.
And how was the methamphetamine? How was it contained or stored?
I believe it was in individial packages for some of them.
Okay, so multiple packages.
Yeah, there's multiple packages within it.
Okay. And do you remember what those that packaging looked like at all?
I think it was plastic Ziploc and like tied on the ends.
Okay. And did that, I guess, was that notable to you in any way?
Yeah, absolutely.
And how so?
So typically, when people are dealing drugs or purchasing drugs from the street, it's usually a plastic bag tied off. It's not like in a, I guess you'd say, a dispensary packaging that you would normally see like a professional. It's very common among street drugs to be packaged that way.
Okay. And you had said you believed it was about 30 grams of methamphetamine.
Yes.
When you are just generally in your experience, when you're locating methamphetamines in possession of people, did that quantity stick out to you?
Absolutely, yes.
Okay, and how so?
So typically with a user, it is a small amount. Users don't typically have a lot of money to purchase large amounts of drugs. So they are usually purchasing $10, $20 at a time. So they have very minimal amounts of that drug.
Okay, and then just because I don't want to speak for everyone here, but I'm guessing a lot of us don't use meth.
Yeah.
How much is like a little bit?
So like a gram is usually like a user amount. Typically you see that among users is usually a gram at a time. So that's usually as soon as they get their money, they purchase as much as they can, and it's usually not more than a gram or 2 grams most.
Okay, and so that 30 grams was significantly more than the 1 or 2 grams you would
Absolutely.
expect.
Yeah.
Okay. And then speaking now about the cocaine that you also located. And I apologize because going through the reports, where exactly did you locate that?
I believe the cocaine was in the driver's side door. You know how there's a slot for storage right there? I believe it was just sitting there.
Okay, and do you remember how much cocaine?
I believe it's around 5 grams.
Okay. And did you test that substance?
I did.
Okay. And I guess first of all, how did you test it?
I true narc tested it.
Okay. And what was the result of the true narc
I
test?
believe it came back as crack cocaine or positive for cocaine base.
Okay.
Yeah.
And with, okay, I'm gonna kind of run through the same sort of questions I did with methamphetamine. With the cocaine, first of all, how was it stored or packaged?
I do not recall at the time. I can look back and refer.
Yes. Do you have a copy of the report right there?
I do.
Okay. I just want to make sure that everyone's clear that what you're looking at. So.
I'll have to apologize. I worked nights last night, so I have not slept since my shift.
Understandable. If you're unable to refresh your memory from the police report, that's fine. I just want to give you the option to say.
I just noticed something that's irregular. I can appreciate you don't remember, but it's important for you not to testify from your police report. So if the prosecutor would like to point out a certain part of the report for you to refresh your memory, I don't have an issue.
Would that be helpful for you, sir, to refresh your memory?
Yes.
So I'm going to find it here. Make your correct page to refresh your memory. This should be the pages that I would be referencing that you but referencing the report.
And what was my question again?
It was this, no, you're fine. It was how the cocaine that you located, how it was stored or packaged.
I believe it was in one plastic bag. It was all put together.
Sorry. Have you finished refreshing?
I have.
I'm going to take the report back here for the report. So you said that the cocaine was in one singular plastic
I
bag?
believe so, yeah.
Okay. And was the quantity, the 5 grams, was that significant to you in any way?
Yeah, 5 grams is it's a larger quantity, but it's not uncommon for some people to have that much on them.
Okay.
For personal use, I think I usually see around 2.5 grams, 3 grams at a time.
And then, while searching the vehicle, did you locate anything else of note?
Underneath the driver's seat in a black bag, I located a firearm, the methamphetamine, cocaine, and I believe I located a pipe in the center console.
Okay. And then did you search the entire car or did you just search the front seat?
I searched the entire car.
Okay. Did you find anything notable in the rest of the vehicle?
Just some steel wool and other things that would typically go along with a glass pipe. That's
You said it's still what?
steel wool.
Steel wool?
Yeah,
What's that?
it's typically used as a filter within glass pipes or used to help people smoke methamphetamine.
Oh.
And when you had detained Mr. Hodge, did you conduct any sort of pat down on his person?
I did. I searched his person.
Okay. And yes, first, why did you do that?
I had searched the vehicle and at that, well, open intox is an arrestable offense in the city of Lansing. I just didn't know if I was going to show discretion or not from that based off of what I was located in my search.
And did you find anything of note when you conducted the pat down of Mr. Hodge's person?
I did.
And what did you find?
I located $6,000 in cash.
And why was that notable to you?
That is a large amount of cash, especially in 2024. Typically, people use credit cards or debit cards.
And did Mr. Hodge provide a reason for having that amount of cash on this person?
I believe he said it's his girlfriend's money from the bank.
Okay. And did you take part in a search of the trunk of the vehicle?
I did.
And did you find anything of note in the trunk of the vehicle?
No.
And are you aware if any, if Officer Meekoff, the officer that you were dispatched with, if he found anything of note?
I do not recall.
No further questions.
Thank you. It's Officer Rincon.
Rincon, yeah.
Either
Rincon. Fine, yeah.
Well, I want to make sure that I do it right, okay? My name is Attorney David Carter. I represent Mr. Hodge in this matter. I'm going to ask you a series of questions. If there's a question you don't, if there's a question you don't understand, please let me know and I'll try to rephrase that. Fair enough? All right. And second of all, I'm going to try to follow the same pattern as the prosecutor so I don't catch you off guard, just kind of give you an idea of where I'm going with this. In the date in question, you were dispatched to LAFQ for a fraud complaint, correct?
Correct.
And as you got there, did you abandon that fraud complaint?
I did not.
Okay, but you saw a vehicle, correct?
Correct.
Did that vehicle come through dispatch as somebody involved in the fraud complaint?
It did.
And when you approached the LAFQ, was Mr. Hodge in the vehicle already, or was he walking outside the vehicle?
I do not recall if he was walking out when I got there. But at point of contact, he was sitting in the driver's seat.
Okay, and was the vehicle running?
I do not recall.
Did he have the keys with him?
He did.
Okay, and where were the keys?
In his pocket.
Okay, so the vehicle.
I believe it was a push start, so they can run from inside your pocket.
Fair enough, but you don't recall asking him to shut off the car or anything like that, correct?
I do not.
And as you approached him, you saw an open intox. Is that your testimony?
I did.
And what was the open intox?
It was a can of alcohol. I don't remember what brand it was, but I remember it stood out to me.
Okay, so you walk up to make contact with the driver. You see a can of what you believe is alcohol, correct?
Correct.
Could you tell if the can was open or not at that time?
Yes.
And could you tell, it's a can, it's not a see-through container, correct?
Yep.
And so you don't know if it was empty, correct?
Correct.
Okay. So you asked Mr. Hodge to step out of the vehicle at that time?
I do.
And what was your next action after you asked him to step out of the vehicle?
We walked to the rear of the vehicle and continued our conversation.
And at that time, was Mr. Hodge free to leave?
No.
Did you read him his rights at that time?
I did not.
Okay. Then after you had talked to Mr. Hodge at the rear of the vehicle when he wasn't free to leave, what was your action after that?
I believe I asked him if there was anything in the vehicle I should know about.
And I can appreciate that. But after that conversation, I don't want to get into the conversation in the rear of the vehicle. After you had that conversation, what did you do?
I put him in handcuffs. I placed him in handcuffs. Yeah.
You put him in handcuffs. And this was before you accessed the vehicle to see if there was, in fact, any alcohol in those cans, correct?
Correct.
All right. And then at some point in time, you went back to the front of the vehicle?
I did.
And where was Mr. Hodge at that point?
Secured in the back of my patrol car.
All right. So you said at some point in time, you told him that you were going to search the vehicle, correct? And he got nervous, right?
Yes.
So you told him you were going to search that vehicle prior to actually picking up the can to see if there was any alcohol in it, correct?
Yes.
But you told him you were going to search it and he got nervous, therefore you put him in cuffs. Isn't that correct?
I put him in cuffs because of another factor.
Okay. And what was that other factor?
His girlfriend approaching our investigation and adding another element to it to where, yeah.
Fair enough. So you put him in cuffs. Was he free to walk around when he was in cuffs?
No.
Okay, so the nervousness that you observed him walking around and pacing was prior to him being put in cuffs, correct?
Yeah, he was nervous prior to being in cuffs.
And that was when you told him he was going to search the vehicle, even though you didn't know if there was any alcohol in those cans, correct?
Correct.
All right. So then you get to the vehicle and you decide to what at that point? You put him in cuffs, you detain him in the squad car, then you go back to the vehicle?
Yes.
And what do you do at that point in time?
I searched the vehicle.
Okay, what was your very what did you do the very first thing when you started to search that vehicle?
Open the door.
Fair enough.
Yeah.
And then what?
Search the driver area.
Okay, so then you open the door, you're starting to look around, correct?
Yeah.
You look inside the armrest. What did you discover first?
I believe I discovered the cocaine in the driver's side.
Okay, so you discovered the cocaine in the driver's side.
Yeah, the door.
And then from there, what did you do?
I moved. I usually start at the door and move.
Okay, fair enough. So you saw the drugs in the driver's side arm, the handle area, is that correct?
Correct.
And then did you look under the seat at that point in time?
I believe so.
Okay, and that's when you found the fanny pack with other items in it, correct? And then, that's how it progressed, correct?
Mhm.
All right.
Is that a yes?
Thank you, Your Honor. And what is the charge of open intox? What is that?
It's a misdemeanor.
What are the elements of open intox?
A container inside of a vehicle, an alcoholic container that is open. The seal has to be
with alcohol in it, correct?
Yes.
Because if I'm if I drank alcohol at home and I'm taking the deposits to the store, there's going to be an empty can, correct?
Correct.
All right. And you indicated to him before you searched the vehicle, before you even checked the cans, you were going to search the vehicle because you had probable cause. What was that probable cause why you could search that vehicle?
Plain view doctrine.
And okay, and what was the purpose? What was the plain view doctrine that you were going to search for?
The plain view of the open end box.
Okay, but yet you had not even touched the cans. You haven't even looked into the cans until you started searching other areas. Isn't that correct?
Correct.
And had you found, if you had actually checked the cans and had there even been the slightest bit of alcohol, why would you be able to search the rest of the vehicle?
Because with open container, if you're saying if there was the slightest bit of alcohol in it,
yes,
it now gives you probable cause to search the entirety of the vehicle for any.
On what grounds? What's the probable cause? You secured the evidence of the crime in which you saw. So what probable cause would you have beyond that crime to start searching that vehicle?
For any other open containers or any other elements of that crime.
What other elements of the crime is there to an open intox that you hadn't even checked the can yet?
Multiple containers.
You didn't see any multiple containers in clear view when you walked up the car, isn't that correct?
I did not. I saw the two in the center console.
Thank you. Thank you. I have nothing further.
Well, I just need to follow up. Did you ever check the cans?
I did.
Okay, was there alcohol in them?
Yes, they're half full and cold to the touch.
Thank you. When you were describing the location of the open alcohol containers, you were describing it as the center console. When you say that, do you mean like they're in cup holders, or do you mean like they're like tucked like underneath a compartment, or how are they?
Correct. In cup holders in the center console.
Okay, where someone would store drinks that they're drinking?
Typically, yes.
Okay. And when you opened the car door to do the search of the vehicle, you said you first saw the cocaine in the door.
Absolutely.
And before, or when you were looking at the door of the vehicle, were you able to see the cocaine, or how visible was the cocaine?
I opened the door and I didn't have to manipulate anything. It was resting right in the pocket of the storage. So I could see the white and the plastic baggie, which is typically narcotics.
And then after you saw the presence of suspected cocaine in the vehicle, at the very first thing you looked at, after that, you proceeded to search the vehicle?
I did.
Okay. No further questions.
May this witness be excused?
Yes, he may.
Thank you, Officer Renfon, you may be excused.
Thank you, Your Honor.
I just need to advise you that there is a sequestration order, so you're not to discuss your testimony with any other witness, okay?
Okay.
Thank you. You can call your next witness.
Thank you, Your Honor. People will call Officer Nolan Meekoff. Not to get him.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury. Thank you. You can have a seat. State your first and last name and spell both.
My name is Nolan, Nolan. Last name is Meekoff, Meekhof.
You can proceed, counsel.
Thank you, Your Honor. Good morning, Officer Meekoff. How are you?
Good, myself.
Doing well. Where do you work?
Thanks for this one.
And what are your duties?
Right now, I'm a patrol officer.
Were you working as a patrol officer on February 1st, 2024?
Yes, I was.
And on that date, were you dispatched to the, excuse me. Am I doing stuff right there? To the LAFCU bank?
Yes, ma'am.
Okay. And why were you dispatched on that day?
We were dispatched there for a suspicious situation outside the bank. There's a female happened there regarding to have a potential fraudulent check. Went there typically with those, the ID of the person, the bank see charges on their end, kind of see what's going on. Ran in there initially, and then ran into Crystal Thomas Hodge.
Okay. So as far as your encounter with Mr. Hodge, what did that entail? What was your encounter with him?
So I was the second officer to respond to the scene there. My partner had been there probably about a minute or two before myself. Initially, I saw Hodge outside the car, talking to my partner. Female, we were sent there initially before we was inside the bank at that time.
And to the best of your knowledge, did the officer you were working with, did he conduct a search of the vehicle?
Yes.
Did you assist in that search at all?
I did, yes.
And where specifically did you begin the search of the vehicle?
I specifically began the driver's side.
Driver's side?
Yep. Then my partner's on the passenger side. I just see the truck area after that initial driver's side search.
Okay, and so you said that you searched the trunk area?
Yes.
And did you discover anything of note in the trunk?
There was a backpack in the back that had a scale on it.
And can you describe the scale of it?
It's a little blue digital one. Had a 0 and then a G, which typically was weighing smaller things, like those grams and stuff like that, which sometimes can be used for narcotics.
Okay, and so that kind of leads into my next question. Was that scale notable to you in any way?
I mean, honestly, based on anything in narcotics, I've seen scales similar to that, yes.
Okay. And was there any residue or anything on the scale at all, or was it just the scale?
Just the scale itself.
Okay. No further questions.
Thank you. Officer Meekhof?
Yes, sir.
Officer Meekhof, my name is Attorney David Carter. I represent Mr. Hodge in this matter. I'm going to ask you a series of questions. If there's a question you don't understand, please let me know and I'll try to rephrase it. Fair enough? I'm also going to try to follow, even though it was very short, direct, I'm going to try to follow that same pattern so that you're not caught off guard. Okay?
Okay.
All right. So you, on the day in question, you arrived at Lafton, correct?
Yes, sir.
And it's your testimony that the other officer arrived before you, correct?
That's correct, yes.
And he was talking to Mr. Hodge?
At that point, they were already talking outside the vehicle, yes.
And where was this conversation taken outside the vehicle?
When I pulled up, I saw them by the driver's side.
By the driver's side?
Yes.
So was Mr. Hodge in handcuffs at that point?
He was not in handcuffs at that point, no.
Did you see where that conversation headed? I mean, did they stay there at that point or did they move around?
Well, we proceeded to the back of the vehicle at some point. I'll tell you, initially pulling up, there was a vehicle that was in 2 parking spots. There wasn't a female we were talking to, so I thought we had something completely different going on.
All right.
Compared to what we called it.
And when you walked up on Mr. Hodge and your partner, they were on the driver's side door?
Yes.
And did that move towards the back of the vehicle?
It did, yes.
And when did Mr. Hodge get put in handcuffs?
Mr. Hodge got put in handcuffs after initially we had Crystal come out. Both of us talked for a while. I went inside and Hodge was in custody after when I came out, which I was out there during that.
Okay. And prior to you going into the bank or the credit union, whatever we want to call it, had you informed Mr. Hodge that you were going to be searching the vehicle?
I did not inform him, no.
Do you know if your partner had informed him that you?
I cannot recall specifically, no.
All right. So at some point in time, you come back out of the bank or the credit union. Mr. Hodge is in custody, correct? Is in handcuffs, right?
At that point, would be yes.
And did you see where Mr. Hodge was at that time? Was he Was he in a squad car at that time?
Yes.
Okay, so are you assuming he was in handcuffs because he was in the squad
He
car?
was in the backseat of my car, yes.
All right. Then you guys, you and your partner conducted a search of the vehicle, correct?
Correct.
And this caught me. You did the driver's side of the vehicle, correct?
Is that a yes?
Is that a yes?
Yes.
So you started your search at the driver's side of the vehicle and your partner did the passenger side of the vehicle. Isn't that correct?
I believe so, yes.
All right. What did you, when you opened the door, what did you first do?
What I first do?
Yeah.
In terms of searching?
Yes.
Well, I mean, first thing I noticed in the center console portion, there's open alcohol containers. So I
Okay.
found that initially. Pretty much I went from middle end, and at that point, my partner there seen narcotics, which were at the door.
Okay. So your partner saw narcotics in the passenger side of the vehicle?
Driver's side.
Okay, I thought you were at the driver's side.
I was.
So your partner and you are at the driver's side both searching at the same time?
It's my understanding when he was placed in custody, that's my partner that observed the narcotics first.
Okay, I don't want to know what your understanding is. I want to know what you were doing, what you were observing. So you and your partner is on the driver's side of the vehicle starting to search the vehicle?
I believe I started the driver's side, he was the passenger side.
Okay. Your partner found some narcotics, correct?
Yes.
Where did he find those narcotics?
It's my understanding they're by the driver's side window, sitting on the door right there, where you open the handle.
Okay, maybe I'm a little confused. Did he had already started searching the vehicle before you started searching it?
My understanding and remembrance, I believe he already had those prior to us actually doing a full search of the vehicles.
You believe what?
I'm sorry?
You say you believe what?
It's my understanding those were obtained prior to us searching the rest of the vehicle.
Okay, so that when you say obtained, he had located those before searching?
Yes, what I can recall of me beyond oath in the stand is, he observed these narcotics prior to us searching the car.
Oh.
At least when I was involved with that, so.
Prior to you and your partner searching the vehicle, when I'm a little confused, so I have to back up.
Okay.
You come out of the left queue, correct?
Come out of last queue?
Yeah, you come out of left queue, correct?
At some point, yes. Yep.
Are you having a hard time understanding where I'm going?
No, honestly, in terms of when I went to the bank and when I went out, honestly, I'm a little hesitant about that.
Why are you hesitant about
that? Just the timing of it.
You don't remember what you did that day?
No, not verbatim exactly.
Okay,
I mean,
I'm not trying to trick you, so
No,
I'm just
I
trying to
understand,
get
yeah.
your what happened. I wasn't there, you were. And you're an officer, correct?
Yes, sir.
And you're prepared to testify today, correct?
Yes.
Did you read through your report before you took the stand?
I did, yes.
All right. So you arrive at left queue.
Yes.
And your partner's already talking to Mr. Hodge, correct?
Correct.
And then you say that a third person comes out of the bank, correct?
Yep.
And no search of the vehicle has happened yet, correct?
Correct. Yep.
And then you go into the bank with this other person, correct?
Not with the other person. No.
Oh,
The
okay.
other person was out there.
Okay, so she stayed there.
Yes.
The other person stayed there and you go into lap queue, correct?
Yes.
And how long were you in the lap queue for?
I'd say approximately 10 minutes.
10 minutes.
Yep.
And when you came out of lap queue, that is at the point in time you know that Mr. Hodge is in handcuffs in a squad car, correct?
At that point, I was informed he was being detained. I assisted my partner doing so.
You assisted him?
Yes.
Okay, so you help him handcuff Mr. Hodge and put some in your squad car?
Yes, in the back seat, yes.
And okay, all right. So did you and your partner now discuss we're going to search the vehicle?
Yes, at that point.
All right. And so did he tell you he already started searching the vehicle?
Not to my recollection, no.
Not to your recollection. Would that be uncommon to have Mr. Hodge not being detained and then a squad car starting to search a vehicle without help with another officer?
Typically, it's a two-person thing.
All right, so that's what you want to do. You want to remove the people away from the thing you're going to search, correct?
Yes.
So you guys have a discussion on searching the vehicle, right?
Yes.
And he goes to the passenger side of the vehicle and you go to the driver's side of the vehicle, correct?
Yes.
To search the vehicle, correct?
Yes.
Oh, yes.
All right. So your first step is to open the driver's side door, correct?
Yes.
And what did you do when you opened the driver's side door? What did you do at that point?
Search center console, underneath the seat, one point in the door as well.
Okay. And you didn't find any cocaine in the door, correct?
I didn't know.
Or any narcotics in the door, correct?
I did not know.
But your partner did, who's searching on the opposite side of the vehicle, correct?
Correct.
And when you say you searched the console, what did you do? Did you
open the console,
Okay.
go through it?
All right.
Yep.
And what was your understanding of why you were searching the vehicle?
Well, we had open alcohol container. On top of what we initially had, there's such a situation, car being parked. Hodge at the time was not being cooperative with us either, which for us gives us a reason to pain. Based on all of that and open alcohol, I figured it was more.
Okay, so you were gonna search the vehicle on a hunch?
On a hunch?
Yeah.
I mean, with open alcohol container and Hodge, hovering by the driver's side prior to us even going through the car, I suspect there was something in the car, yes.
Okay. You didn't have any, outside of the open intox, you didn't have any other suspicious of criminal activity afoot, did you?
Aside from the situation itself and the open alcohol, no.
All right. And the open intox is a misdemeanor, correct? And I think you said, did you say that Mr. Hodge was being uncooperative?
At one point, yes, initially given the ID and talking with us, yes.
Is that another reason why you want to search the vehicle?
Not necessarily, no.
I have nothing further.
I just have a question. Were you present when your partner located the cocaine in the door?
Yes.
Okay. Because I'm lost on the timeline. Did he locate it before you searched or while you were searching?
Before.
Before? And you saw him locate the cocaine?
He informed me of it, honestly. Up here today, I can't remember exactly how that turned out, exact order, but he did inform me prior to searching.
Oh, so while you're detaining Mr. Hodges, he informed you of this?
At that point, I'm aware, yes, which with the narcotics and everything else, that's when we detain him.
Okay, so you are detaining him, cuffing him, helping your partner put him in the back seat of your patrol vehicle. Your partner at this time indicates that he located narcotics in the door. And that was not any further probable cause for you to search? You all didn't consider?
That was probable cause technically, yes.
Did he tell you how he located it in the door?
I can't recall that, no.
Okay. Redirect.
I had no further questions, Your Honor.
Any cross based on my questions?
No.
No, Your Honor.
Thank you. There's a sequestration order. You're not to discuss any portions of your testimony with any other officer, okay? You can be excused. Any further witnesses?
None for the people.
Participants calling witnesses?
No, Your Honor.
Argument.
Thank you, Your Honor. Mr. Hodge, today he is charged with multiple counts. The first being the possession with intent to deliver of methamphetamine. The testimony from Officer Rincon established that they that he, when conducting a search of the vehicle, located under the driver's side door, or excuse me, under the driver's side seat, 30 grams of methamphetamine individually packaged in individual tied off baggies, which in his experience is the means of packaging drugs for packaging narcotics, I should say, for distribution. And that also he found that the quantity was a significantly higher quantity of methamphetamine than would just be found in his experience on a typical user who's just possessing the drugs to consume them themselves. Additionally, Officer Meekoff testified that he located a digital scale in the trunk of the vehicle, which, while obviously there are perfectly mundane reasons to possess a digital scale, taken into account with the large quantity of methamphetamine, the way that the methamphetamine was packaged, and also the $6,000 that was found in cash on Mr. Hodge's person would lead, would establish to a probable cause standard the elements for the possession with intent to distribute, given that Mr. Hodge was located in the driver's side seat of the vehicle prior to being removed from the vehicle, and he would thus have constructive possession of the items in that vehicle. Next, the count for the possession with intent to distribute for a controlled substance, in this case, cocaine or crack cocaine. Officer Rincon observed the cocaine located in plastic baggy packaging in plain view in the driver's side door. Again, closely located to where Mr. Hodge previously was seated, and again taken into consideration along with the large quantity of cash, the digital scale, and the large quantity of the other drugs in the vehicle. It's the elements of the possession with the intent to distribute for the cocaine in this instance have also been met. Mr. Hodge is also charged with carrying a dangerous weapon concealed in a vehicle. This was a vehicle that was occupied and potentially being operated. There's some disputing testimony about whether or not the vehicle was actually turned on, but either way, Mr. Hodge was located within the vehicle where the firearm was located underneath his person in the driver's side seat, thus satisfying the elements for count number 3. As previously stated on the record for count number 4, the parties have stipulated to Mr. Hodge's prior criminal record for his conviction of home invasion first degree, and his rights there's been no argument made that his rights to possess a firearm have been restored at this point. So the elements for that count have been met as well. And then for the following felony firearm counts, obviously the weapon was present in the vehicle with Mr. Hodge when he was possessing while intending to deliver both the methamphetamine, cocaine, and being a felon in possession of the firearm. As far as any potential argument or dispute about the cause for the search or what allowed the search to take place, the officers spotted in plain view the vehicle open alcohol containers. From there, they had probable cause to search the vehicle for further evidence of the crime of having an open intoxicant in the vehicle. And additionally, although there is some dispute about the exact sequencing of events, Officer Rincon and Officer Meekoff's concurring with what Officer Rincon stated, once basically the cocaine was discovered in plain view on the driver's side door, they then had probable cause to search the rest of the vehicle for further evidence of possession, in this case, possession with intent to deliver of that cocaine. So at this point, any potential issues of fact should be decided by a jury, and I believe that the elements have been met to a probable cause standard. And that's if this case be bound over as charged.
Mr. Carter.
Thank you, Your Honor. We'd be opposed to bind over on all counts, Your Honor. This is basically an unconstitutional search. They have probable cause to reach in and check the status of what's in those cans, but they didn't do that. They decided they were going to do a full-out search. Well, you have, in order to have a full-out search on something like this, you'd have to be looking for evidence of a crime that he's being arrested on. That would be the search incident to arrest doctrine. And here he's being detained for open intox. suspicious of open intox actually, because nobody actually checks the cans until after they've decided to search the vehicle. So on the grounds that this is an unconstitutional search, I'd ask the court not to dismiss this case.
Mr. Shosky, I appreciate that you went through the elements of the controlled substance and the weapons and all the testimony that's provided about that, but I don't think it's without dispute that there is some confusion about timelines and how we get to a search locating cocaine in the driver's side door when one officer is testifying that he started on the driver's side while the, well, let's be specific, Officer Meekoff is testifying that he started on the driver's side for searching when Officer Rincon is on the passenger side, but then Officer Rincon is the one who locates the cocaine in plain view in the door. And then Officer Meekoff, in response to my question, says that when he was told by his partner before they searched that he located the cocaine in the door. To say that the court's confused is an understatement. I have no clarification as to the timeline because obviously these two testimonies have some conflict that I'm going to have to work through. But I think that the issue of the legality of the search of the entire vehicle for an open intox is an issue that needs to be addressed. And I don't know if you need to brief that issue, but it needs to be addressed. What gives them the authority to search the entire vehicle under the seats, the trunk, based on an open intox? Based on what they stated was, there was 2 cans in plain view. One officer states he didn't even search the cans, at least initially. He initially is searching other things. And if the testimony was unequivocally that when he opened the door, he sees cocaine, then that'll clear this up. That's not what we got. And so I want to know, how did we get to a whole search? So I'm happy to give you time to research that and brief that if that's what you need to do, or you can respond now.
If I could just respond briefly, and then if necessary, I can prepare a brief. It's my understanding that for the charge of an open intoxicant in a vehicle, I guess, obviously, yes, they, as part of that search, they would be looking at the specific cans that they saw in plain view. But additionally, when they're conducting an investigatory search, they're searching for corroborative evidence of the crime. They're searching for evidence that makes things more or less likely to have occurred, more or less likely for there to be open intoxicants in the vehicle. So I would state that, or I would argue that they would be permitted to search the rest of the vehicle, given that there could be other open containers. There could be other, it's not that generally speaking, things are.
Let me stop you here, because if we're talking about open intox in a vehicle, wouldn't it be true if there was an open intox in the trunk of the car, that wouldn't count as something that would violate the law?
It would, Your Honor.
And not if it's in the back of the car, because they can't access it, correct? Because you can transport alcohol that's been opened, long as you're not accessing it.
I guess I would argue that if it's within arm's reach, it's accessible by the passengers of the car.
But my question was if it's in the trunk of the car.
When it comes to the search of the trunk of the vehicle?
Let's say you went to dinner, you had a bottle of wine, and then they capped it back on and you put it in the trunk of your car. Are you violating the open intox?
No, but when it comes to the search of the trunk, that took place.
Well, I'm not talking specifically about that. So my thing is, you're saying that the law allows them to search for corroborating evidence. I'm trying to understand how looking under the seat of the vehicle before actually looking into the cans to see if they're open corroborates or is looking for evidence to corroborate that there's open alcohol in the vehicle. That's what I'm trying to understand.
Yeah, so, obviously searching those cans is definitely a necessary part of the search, but especially since we're talking about underneath the front driver's seat, if there are open containers of intoxicants under the open or under the driver's side seat, then at that point, that is something that's within reach of the driver or a passenger of the vehicle. So that would be further evidence of the open intoxicant.
I suppose if they had actually checked the cans before they looked under the seat, but that's not the testimony. They looked under the seats and in the door before even checking the cans. I had to ask if they even ever checked the cans because that was never asked. Did you ever check the cans? Was there alcohol in there? Yeah, there was, and it was cold to the touch. But the emphasis was placed on the search and what they found under the seat, in the trunk, in the driver's door. But I'm trying to understand, how do we get there from probable cause to search for open up intox? How do we get to the door? And again, if the testimony of either Officer Rincon, who works nights and is a little hazy, or Officer Meekoff, who was present but hesitant, had been that no, when Officer Rincon opened the door to ask the suspect out the vehicle, in plain view, he saw some narcotics, then that'd be different, but that's not what we have here.
And I understand that the court is obviously presented with the difficulty of having two somewhat contradicting testimonies. I would say from Officer Rincon's testimony, when he went to conduct the search of the vehicle, that is when he saw, when he opened the door, he looked down and saw the cocaine in plain view. That was my understanding of his testimony. I understand
that.
What?
That's not what he stated, though.
How did he?
He stated that he did find the cocaine in the door, but he never testified that when he opened the door to search the vehicle, that there was cocaine in plain view. The other testimony is obviously that would conflict with what his partner to testify was, that one officer, Officer Rincon, is on the other side of the door.
And I'm not disputing the fact that that complicates things significantly. And I apologize. I remember asking Officer Rincon when you opened the door.
I think on your redirect, you did ask him that.
Yes. And when did you see it? And then he stated that he could see it without having to manipulate anything in the door. And then after from his testimony, he stated that after he observed the cocaine, that was when he proceeded to conduct the rest of the search. So from his testimony, that would then establish probable cause for continuation of the search. I agree that there is some potential issues between the testimony between the two officers, but I would argue that that's a factual dispute to be decided by the jury.
Correct. I think that their testimonies clearly conflict, but I still need a brief on the legality of searching the entire vehicle. Let's say that the reason why they searched was strictly based on open intox. I want to know what gives them the authority. Does the law give them the authority to search the entire vehicle based on those things? If they were to find that there was, because if they could have opened the cans or looked at the cans and they were open, wouldn't that have been sufficient to conclude their search?
It would have been, I would say that it would be sufficient to conclude that there was for sure open intoxication happening, but then at that point, there's still further investigation that they'd be permitted to conduct, given that they could be searching for corroborative evidence of the crime that had been committed. Just because we find a body in a homicide, that doesn't mean that we're done investigating the homicide because we have evidence that the crime was committed. We still need to find other evidence of, who was involved, where were things located, what was going on around that issue.
Correct, but I'm talking about a search.
Yes, and so I apologize for not being clear there. I'm stating that a search of whatever surrounding either premises or cell phones, those types of things in the homicide example, that would be appropriate then. And I'm not saying that because they could have succinctly found 100% proof of the crime, that means that their investigation needs to stop. I'm more than happy to brief the issue. I would state though,
why wouldn't their investigation need to stop if they found proof of 100% proof of the crime?
Well,
should we now go get a search warrant for their home and see if there's evidence to corroborate? No, they've got enough evidence at this point if the evidence was right there. We're not talking about a complex criminal issue. It's a misdemeanor allegation of open intox in a vehicle. Very limited elements need to be met for that purpose. How do we get around going directly to the open-end talks, or what we believe to be open-end talks before we search the entire vehicle and then get around to seeing if there's alcohol in there. That's the issue I need brief. Do they have the right to search the whole car?
Okay, if I may just clarify for the sake of writing the brief, it's not my position that the search of the trunk was based off of probable cause for the open intoxication. The search of the trunk took place after narcotics and weapons had already found. And I don't believe that I would be able to brief that in good faith and put that before you. So I'm not trying to argue.
Understandably so. I can understand that if they found narcotics under the seat or in the front door, that now we're going to search the entire car. But I want to know, how do we get under the driver's side seat and door first? That's what I need. I need some clarity on that.
Okay, yeah, I could prepare and file a brief for the court.
Okay, sounds good. Mr. Carter, you stood up and sat down about 12 times. So I don't know if you were trying to say something.
In law school, they tell you not to say anything if you're winning, so that's why I said.
I wouldn't go that far. I wouldn't go that far. I'm just trying to get some clarity because I'm confused about the timeline, and that could just be because the testimonies of the two officers conflicted with each other.
And I think every time that I stood up, the reason why I sat down is you were identifying my issue with your response to the prosecutor.
Something. So we'll adjourn this to allow time for there to be a brief as to the issue of the authority to search the vehicle. Obviously, you don't need to resolve any issues of the conflict testimony. The court can resolve that on their own. But I want to know about that issue before I make a ruling on the probable bind over a probable cause as to counts 1 through 5. Let's see. We would like to have briefs. Today is the 4th.
Your Honor, if you would take into consideration, I start a homicide trial on the 22nd.
Are you saying that is to take into account when she's going to get her brief done?
My response.
Oh, your response. Okay, no worries, because I was going to say she can get her brief to us by the 19th, and then you can respond by the 3rd.
And that's why I brought up I think it's a 2-week homicide trial.
Oh, okay. So you're
22nd.
not going to be responding by the 3rd. Let's see.
I could probably do it by the 10th if you allow me that leeway.
Okay, so with that being stated, I'm going to give her more time since it's not imperative that you're going to get it done. What date did I tell you before?
You told me April 19th.
April 19th. We'll give you the week. We'll give you to the 22nd when he's starting his trial. And then you said you can have it back to us by the 13th.
Yes, I leave on vacation on the 13th, so I'll get it in by the 10th.
Okay, sounds good. And then we'll reset a hearing after. When do you come back from vacation?
I'm only off that week.
Oh, just for the weekend? Okay.
No, for the week. That's
For that full week?
12
Okay,
days.
so a week, anytime after that, we can reset it. Do the 23rd. Does the 23rd work for you?
Yes, Your Honor.
May 23rd at 10:30. Any additional matters for today's record?
Nothing from the people.
Nothing for the defense. Thank you.
You're all set for today.
May I approach?
You may.
Thank you.
Thank you.
The non-pink highlight. And
Do you have a new date for Mr. Jones?
Oh,
Commented that they
we
wanted.
can provide them a new date for Mr. Jones. And here we are still continuing. So many notepads in here. And then Mr. Freeman. Are we running? It's 12 o'clock. Are we running an exam? You may.
We can do the 19th at 1:30.
Thanks for the extra time.
No problem.
That's a Thursday, correct?
Friday.
Friday the 19th,
Friday the 19th.
April 19th. Yep.
I can do that. Thank you.
Sounds good. Is this a plea?
Yes, that was my understanding that
Oh,
Mr. Ryder
okay.
accepted it.
You have a plea sheet?
I'm filling it out right now. Hey, Richard.
Yes. Careful. Okay, back on the record in the matter of the people of the state of Michigan versus James Minor. And then Mr. Minor, I have a plea sheet here. It says the people are offering for you to plead guilty to added count 5 of aggravated domestic assault. And an added count 6 of attempted interfering with the crime report. No objection to sentencing under 769.4A, and they will dismiss the remaining counts. Is that accurate as to your understanding of the plea offer?
Yes, Your Honor.
Do you want to accept that offer, sir?
Yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Thank you. To put your hand down. I have an advice of rights and plea information sheet. They make those in 2 pages now for whatever reason. This is your signature page. Is that your signature?
Yes, Your Honor.
Did you read page 1?
Yes, Your Honor.
You understand the rights listed there?
Yes, Your Honor.
Do you have any questions about those rights?
No, Your Honor.
And are you willing to give up each of those rights today in order to accept the plea offer?
Yes, Your Honor.
You understand that you have the right to the presumption of innocence. So you're innocent until you're proven guilty, and you have the right to require the prosecution prove your guilt by proving each element of the charge or charges being brought against you beyond a reasonable doubt at your trial.
Yes, Your Honor.
You have the right to remain silent at your trial and not have silence be used against you. You have the right to see, hear, or question any other witnesses that the prosecution intended to call against you at your trial. You could waive your right to silence, testify on your own behalf, or you could subpoena witnesses to trial that will testify for you. You understand that?
Yes, Your Honor.
You also have the right to require them prove again each element beyond a reasonable doubt at your trial. You want to give up all of those rights?
Yes, Your Honor.
Anybody threatening you to get you to give those rights up?
No, Your Honor.
Any promises being made to you that enticed you to give up your rights?
No, Your Honor.
Are you currently on probation or on parole?
No, Your Honor.
You understand that a guilty plea could result in a conviction that you may need to report to your employer?
Yes, Your Honor.
You also may need to report this conviction to a future employer.
Yes, Your Honor.
A conviction of these kinds could have impact on where you can travel or where you can get immigration status. You understand that?
Yes, Your Honor.
As to the added count 5 of aggravated domestic violence, how do you plead?
Guilty.
As to count 6, attempted interfering with the crime report, how do you plead?
Guilty.
Are you entering guilty pleas because you believe you're guilty?
Yes, Your Honor.
That's always the trick question. You hesitated.
I mean, no.
If I may just have a moment, remember.
Yes.
Okay, make a judge.
Okay, my question was, are you pleading guilty because you believe you're guilty?
Yes, sir.
Okay, factual basis.
Thank you very much, Your Honor. Mr. Minor, I want to draw your attention to December 28th of 2023, December 28th. On that date, did you know an individual by the name of Alexa Minor?
Yes.
And how is it that you know her?
That is my wife.
And at that time, were the two of you residing in the same household?
Yes, sir.
And did there come a time during that day, sometime, that the two of you engaged in an argument?
Yes.
And did the argument eventually escalate into something more physical?
Yes.
Can you tell the court what exactly that you did in terms of being physical with your wife that caused an injury?
So whenever I got up, she got up and she had smacked me on my.
What did you do?
What did I do? I physically put my hand around her shoulder to remove her from the door so I can exit the room. Because she put herself in front of the door, so I couldn't get out.
Okay.
The officer who responded indicated in this report that there was a definite redness on one side of her face and on her ear. You recall that?
No.
You don't dispute that, do you?
Yeah. No.
Well, he's disputing it.
Okay.
You can't tell him to change his answer on his factual basis. I also heard him say that she hit him. Did she hit you before you did this?
We was just playing around.
But did she smack you before you moved her?
Yeah, that's what we normally do, but that wasn't
that didn't bring us fighting.
What caused the fight?
Taking my phone and not giving me my phone back. And then she said she would give it to me at a later time.
Okay.
And I went to go leave the situation and she stepped in front of the door, put herself in front of the door where I couldn't leave the situation. So at that time, yeah, I put my hand on her shoulder like this and moved her out of my way so I can leave the house.
Okay, you moved her forcibly out of the way?
I mean, I didn't like shove her, I just.
Okay.
Gently.
Tell the judge what happened in the car.
On the, which time? Because there's.
You assaulted her.
I never assaulted her in the car. Because the window and everything was rolled up.
Okay, I can't accept your plea.
Okay.
Do we have witnesses here for an exam?
I have an officer and I'm able to proceed victimless.
Call your witness.
We would tender a waiver.
Is that what you want to do? You want to waive the exam?
Yeah, there's no point. I mean.
Is that what you want to do?
Yeah.
Okay. And so you understand that you have the right to have a preliminary examination here in the district court.
Yes, Your Honor.
And you understand that the purpose is to require the prosecution put forth evidence to support that they have probable cause that a crime was committed and probable cause to charge you with the crime.
Yes, Your Honor.
Okay, is this offer going to remain open for him?
No, Your Honor.
Okay, so the offer is not going to remain open. You understand that?
Yes, Your
Honor. Okay. Anybody forcing you to get you to waive your preliminary examination?
No, Your Honor.
Is there been any promises made to you that get you to want to waive your preliminary examination?
No, Your Honor.
And I would just state that the people also unequivocally waive their right to a preliminary examination.
Thank you.
This is what the judge just read to you. You need your signature.
No worries.
Thank you. Okay, if you waiver to be freely and voluntarily given, your bind over date's gonna be April 17th. That's the date that the circuit court's gonna get the file from the district court. You don't have to go to court on April 17th, okay?
Okay.
Your next court date will be a pre-trial in circuit court. Your attorney will be made aware of that date. Do you have any questions at this time?
No, Your Honor.
A bond was set at 20,000, 10%. That will continue. Any additional matters for the record?
Nothing from the people.
Your Honor, could we please the court? My client was also ordered to wear a GPS tether. I don't believe that there has been any reports of violations from the tether company. I don't believe police or the prosecutor have received any reports from Mrs. Minor indicating that my client has approached her, harassed her, etc. I believe that he has been, since the date of his arraignment, I think it's a sufficient record such that the court might entertain a motion to have that GPS tether removed. I don't know what purpose it continues to serve. Thank you.
I don't have any allegations of violations of the GPS tether. It's been on tether, it looks like since December. It's April. I'll remove the GPS tether. Other bond conditions, including the no contact order, will continue, okay? So you have to go back down to Ingham County to have them remove the tether. Don't attempt to remove it yourself, okay? Any additional matters for the record?
Nothing from the people.
Nothing further, Your Honor. Thank you.
Thank you. You're all set. Oh, wait, I know this is not the jail in there. They just never moved him. That's what it was.
Is it gonna take a day or two for them?
Ms. Petrowski, on the one that I just told you to brief, the complaint has the wrong address.
Oh, I apologize. I will get.
I will, at the beginning, I got very confused, but I think if the issue is if they use maybe his home address or not.
I will talk to our clerk